ladies and gentlemen. Welcome back to our podcast channel, The Legal Answers, where we answer your questions of law and explain complicated legal principles. I am your host, Rhea.
And I am your co-host Daniel. Today, we will dive into the depths of the ever-controversial, the ever-elusive concept of judicial review.
Yes, that is indeed true. I'm excited today to be accompanied by our esteemed panel of guests, composed of 5 legal professionals who will provide us with extensive knowledge for today's discussion. A key mechanism in upholding the rule of law in the UK is judicial review, which is defined as the process in which the courts examine the legality of decisions, actions, or omissions made by public authorities. Its focus is not on whether the decision is correct on its merits, but rather on whether the decision was made lawfully and fairly with the powers granted by the law. But first, what exactly is judicial review? In the United Kingdom, a single written constitution does not exist. Instead, the constitutional system is based on the common law and other factors, such as statutes, constitutional conventions, and established constitutional principles. One of the most significant principles is the rule of law, which requires all individuals, including the government, to act in accordance with the law and be held accountable for their actions. Judicial review is highly significant constitutionally as it acts as an audit on the exercise of the government's power. It demonstrates the relationship between the judiciary and the executive body, allowing courts to ensure public authorities do not exceed their legal powers. With all this being taken into consideration, today's dialogue will examine how judicial review upholds the rule of law in the UK.
Now, we will introduce our first guest, Ms. Sunita. Thank you for joining us today.
It's an honor to be here.
Could you perhaps explain to us regarding the need for judicial review and to what extent can it be used by the courts?
Okay, firstly, to understand the necessity of judicial review, we must first look at its scope. The basis of judicial review lies under Section 31 of the Senior Courts Act 1981 and the Civil Procedure Rules 1998, as well as more recently, the Judicial Review and Courts Act of 2022. In the UK, the area of legislation governing the role of judicial review is complicated and continuously changing. The basis for having recourse through judicial review are well established and enhance the role of judicial review. In most cases, the foundation or justification of judicial review is found under the doctrine of ultra vires. A decision maker acts beyond his powers, both when he goes beyond said powers expressly granted by the legislation, but also when he ignores the limits laid down implied by the legislation. When there is no legislation involved, the justification of judicial review is found in the common law theory. Judicial review is justified by the inherent power of the courts to develop the common law. It is a judicial creation intended to apply the substantive values of fairness and justice inherent in the rule of law to the decisions of administrative authorities. The scope of the grounds of review is properly determined by 2 principles. The first, a principle of regularity, the second, a principle of non-arbitrariness. The availability of the judicial review procedure properly turns on whether there is an alternative procedure by which regularity and non-arbitrariness can be upheld. To determine the extent to which a decision may be examined through judicial review, courts develop the techniques of amenability, justiciability, and deference in order to establish the availability and appropriate intensity of review. Questions of justiciability and deference involve detailed analysis of the decision in question and of the issues raised by the grounds of challenge advanced by the plaintiff. The purpose of that analysis is to determine whether a decision that would normally be reviewable in principle should, in the light of factors specific to the particular decision and the particular grounds of challenge raised, be reviewed less intensely than usual or exceptionally not at all. However, amenability is the question of whether, in the first place, the exercise of a given power is capable of generating decisions that are susceptible to judicial review. It is common ground that the judicial review procedure extends to governmental acts and decisions. The difficult issue is what other acts and decisions, if any, are properly within the procedure scope. As mentioned previously, Amenability is concerned with the question of who may be judicially reviewed. Traditionally, amenability to judicial review followed the source of power. Exercisers of statutory powers and later prerogative powers were amenable to judicial review. However, the Dactyphon case gave rise to what is now termed the public functions test. The effect of this test is that all bodies exercising functions of a public law nature are, in principle, susceptible to challenge by judicial review. When looking at bodies whose acts and decisions would be subject to judicial review, the most obvious answer would be bodies which consist of ministers, local councils, parole boards, etc.
Well, how about private entities like British Airways or the football club Arsenal?
Well, the acts and decisions of some private bodies can also be subjected to the grounds of review. These are private bodies that perform a public function or have been contracted to carry out a public body's statutory functions. Let's say if British Airways issues an airworthiness certificate, or if Arsenal grants naturalization for its foreign players, the courts will have grounds to review the decisions that were made by these bodies. In terms of the question concerned with what can be reviewed, this is answered through the exclusivity principle. The application for judicial review is confined to reviewing matters of a public nature. In O'Reilly and Macman, the House of Lords established the rule that public law challenges must be brought through the judicial review process and not through private law proceedings. In terms of what issues specifically can be reviewed, that is where the principle of justiciability comes in. Justiciability refers to the limits of the court's power to conduct judicial review. The types of decision which may fall within the range of judicial review include decisions of local authorities, immigration authorities, regulatory bodies, as well as decisions relating to prisoners' rights. In Council for Civil Service Unions and Minister for Civil Service, the House of Lords made it clear that the source of power was not determinative of whether the courts would review. Rather, the matter to be decided was whether the subject matter of the application was justiciable or not. Accordingly, matters that are defined as non-justiciable are the making of treaties, issues of national security, the prerogative of mercy, the grant of honours, the appointment of ministers, and dissolution of parliament. Generally, the court is slow to review government policies which are legitimately formulated. Judicial review is concerned with the question of legality and is not intended to deprive authorities of their policy-making functions. Courts cannot overturn or quash primary legislation passed by Parliament because in the UK Constitution, Parliament is sovereign. This limits judicial review in English law to the decision of public bodies and delegated legislation. The Supreme Court's decision in Miller 2 expanded judicial review into the political relationship between Parliament and the government. The scope of judicial review has also been influenced by the UK's membership in the European Union. Before Brexit, the courts were obligated to verify that domestic law is consistent with European Union law. Furthermore, courts are equipped to hold the government responsible for upholding the law and safeguard individual liberties and rights through judicial review. By making the European Convention on Human Rights a part of the UK's legal system, the Human Rights Act 1998 increased people's legal protection against government abuses of their rights.
1. Based on what you shared, judicial review is a complicated and developing area of law in the UK that is influenced by legislative requirements, case laws, and constitutional principles. I will now acquaint our listeners with Ms. Tara, who will be assessing the standing and sufficient interests of judicial review.
To begin with, the term locus standi refers to the legal capacity of a person to bring proceedings before a court. In judicial review, it determines whether a claimant has sufficient connection to the matter being challenged to justify the court's intervention. So, standing performs an important constitutional function. On one hand, it prevents courts from being overwhelmed by claims brought by mere busybodies with no genuine concern in the dispute. On the other hand, an overly restrictive approach may allow unlawful governmental action to escape judicial scrutiny. So, the statutory basis for standing is found in Section 31, subsection 3 of the Senior Courts Act 1981. So, it provides that the court shall not grant permission for judicial review unless the applicant has a sufficient interest in the matter to which the application relates. So, before the development of the modern sufficient interest requirement, many statutory review procedures granted standing only to a person aggrieved. The phrase remains relevant in various statutory appeal contexts and has influenced the development of judicial review standing. A person aggrieved was understood as someone who had suffered a particular grievance, disadvantage, or adverse effect resulting from the decision under challenge. Courts generally required a direct and personal interest. The modern law of judicial review, however, is founded upon the broader concept of sufficient interest. Unlike the traditional person aggrieved test, sufficient interest does not require the claimant to demonstrate the infringement of a private legal right. Instead, the courts are afforded flexibility to determine whether an applicant possesses a genuine and adequate interest in the legality of the decision under challenge. The Law Commission deliberately adopted the phrase sufficient interest because it allowed the courts to develop the law according to the circumstances of individual cases. The leading authority on this issue is Fleet Street Casual case. The National Federation sought judicial review of an arrangement between the Inland Revenue and casual street workers, alleging that it was unlawful. Although the House of Lords ultimately dismissed the claim, the case transformed the law of standing. Lord Diplock rejected a narrow approach based solely on private rights and stated that it would be a grave lacuna in the system of public law if a pressure group or public spirited taxpayer were prevented from bringing unlawful governmental conduct before the courts. The decision established that standing should not be determined through rigid technical rules, and that the courts should consider the wider constitutional purpose of judicial review, namely the vindication of the rule of law. Consequently, the National Federation marked the transition from a restrictive approach towards a more liberal and flexible understanding of standing. The liberalization of standing facilitated the growth of public interest litigation. Public interest litigation refers to legal proceeding brought not primarily to vindicate the claimant's personal rights, but rather to promote the public interest and ensure governmental accountability. Such litigation recognizes that unlawful decision may affect broad sections of society, and that those directly affected may not always possess the resources, expertise, or willingness to challenge them. The landmark authority in this area is Greenpeace case. Greenpeace challenged a decision authorizing the operation of a nuclear reprocessing facility at Sellafield. The High Court granted Greenpeace standing, emphasizing that Greenpeace possessed substantial expertise in environmental matters, represented a significant number of individuals directly affected by the decision, and was a reputable and responsible organization capable of presenting the issues effectively before the court. The significance of the case lies in its recognition of representative or associational standing. It demonstrated that organizations may be granted standing where they represent affected individuals and where the participation would assist the court in resolving important questions of legality. The development of standing in UK law may be understood as a progression from a restrictive model towards a more flexible and context-sensitive approach. The expansion continued during the 1990s through cases such as the Greenpeace, which demonstrated a growing judicial willingness to grant standing to pressure groups, campaign organizations, and other public interest claimants where important issues of legality and public accountability were involved.
Is it true that in recent years, the courts have adopted a more nuanced and context-sensitive approach?
Yes, standing is no longer regarded as automatically generous in every case. Instead, courts assess factors including the claimant's connection to the dispute, the seriousness of the alleged illegality, and the existence of alternative claimants and the broader public interest. While standing continues to prevent inappropriate litigation, it also ensures that public power remains accountable to law.
Thank you, Ms. Farah, for the succinct exposition. We will now move on to our next guest, Ms. Joelle. Based on your understanding, what are the principles of judicial review?
When discussing the grounds of judicial review, there are several principles that I'm going to highlight. These include the one's barrier and reasonableness, illegality, procedural impropriety, natural justice, and proportionality. Together, these grounds allow the courts to supervise the exercise of public power and ensure that decisions are made lawfully and fairly. One of the most well-known grounds is the one's barrier and reasonableness, also referred to as irrationality. The principle was recognized in the ZCHQ case, where Block de Block described an unreasonable decision as one that is so outrageous in defiance of logic or accepted moral standards that no sensible person would arrive at it. The origins of this principle can be traced to the Associated Provincial Picture Houses Limited and Wensbury Corporation. In that case, the local authority had the power to grant licenses to businesses under given conditions. It was willing to grant a Sunday license to a cinema subject to condition that children below the age of 15 should not be admitted. The House of Lords held that the condition was not unreasonable because it was within the discretion of the town council to make such a decision. What mattered was whether the decision was so unreasonable that no person would arrive at such a conclusion. This became known as the Wensbury test, and over time, the term irrationality and Wensbury unreasonableness came to be used interchangeably.
So, when we talk about irrationality, can this ground arise because important factors were ignored?
Absolutely. We can see an example of this situation in R and Minister for Legal Aid. M's mother and sister had been killed in a rail accident, and the coroner considered that the legal aid would be necessary because rail safety is vital towards public interest. Despite a recommendation from the Legal Services Commission that funding may be granted, the Minister for Legal Aid refused funding. The court held that Minister's decision was unreasonable because it failed to take into account the recommendations from the Legal Services Commission. The case demonstrates that a decision may be irrational not only because of the outcome, but also because relevant contributions have been ignored. Alongside irrationality is the grounds of illegality. At its core, it is a simple requirement. A decision maker must correctly understand the law that regulates their decision-making powers and give effect to it. The Attorney General and Fulham Corporation provides a clear example of this aspect. The local authority was empowered under statute to establish washhouses for non-commercial use by residents. And instead of limiting itself to that purpose, the corporation had decided to operate a laundry on a commercial basis. The corporation was held to have acted ultra vires the statute because it had gone beyond the powers granted to it. The case illustrates that public authorities cannot use statutory powers in the ways that Parliament had never intended to be used. A similar idea appears in Porter and McGill. Here, a local authority exercises power to sell property to tenants in the hope of gaining political advantage in an election. It was argued that as long as some proper cause was being pursued, the exercise of power was lawful. The House of Lords ultimately rejected the argument. The power had to be used for its intended purpose, and that purpose was not to secure an electoral advantage. The conduct was therefore unlawful and in breach of electoral law. What this shows is that even where a public authority possesses a legal power, the power must be exercised in the correct purpose. The importance of following proper procedures is reflected in the grounds of procedural impropriety. Judicial review is not concerned only with what decision is reached, but also with how that decision is reached. A familiar example can be found in the Malaysian Criminal Procedure Code. When a person is arrested, he has the right to be told of the grounds of the arrest and to be afforded legal counsel within 24 hours. If these procedures are not complied with, a habeas corpus can be issued to free the arrested person. Lord Denning quashed the decision because the penalty, namely the loss of the license, was disproportionate to the offence. While the conduct was improper, the consequence imposed was excessive. The case therefore illustrates how judicial review can prevent public authorities from imposing measures that go beyond what is necessary in the circumstances. Taken together, these grounds of judicial review ensure that the public authorities remain accountable under the law. Whether the issue concerns irrational decisions, misuse of power, failure to follow procedure, bias or disproportionate action, judicial review provides a mechanism through which the courts can safeguard legality and uphold the rule of law.
Wow, this is enlightening to know the different ways the judiciary can overturn a decision made by public authorities. Ms. Sharon, on the other hand, will address the elephant in the court that is limiting the power of judges to review public policies. The floor is yours.
Thank you, Rhea. I will now explain some of the limitations and the controls of the judicial review. To start with,
Let's look at the ouster clauses. Ouster clauses are statutory provisions inserted into an act of parliament that attempt to exclude or limit the jurisdiction of the courts from reviewing a public body's decision. The first is total ouster clauses. This provides that the decision shall not be called into questions in any court of law. However, courts view total ouster clauses with hostility because they directly undermine the rule of law. This can be seen in Anisminic Limited and Foreign Compensation Commission. The House of Lords bypassed a total ouster clause by ruling that a decision involving an error of law was a nullity. A more recent example is the Privacy International case. The Supreme Court reaffirmed that the courts retain a strong presumption that Parliament never intends to allow a public body to misinterpret the law without judicial oversight. The second type is partial ouster clauses. This limit the time a claimant has to challenge at 6 weeks are routinely accepted to preserve legal certainty. We can now proceed to judicial restraint. Judicial restraint is the principle that courts should defer to the political expertise and democratic mandate of the executive or legislature. This is based on the doctrine of separation of powers. As a result, matters involving national security, international relations, defense of a realm, and macroeconomics are routinely treated as non-judiciable. This principle was illustrated in GCHQ case. Similarly, in Chandler and DPP, the courts refused to evaluate the wisdom of state defense policies regarding nuclear weapons. As Luke B. Tremblay argues, this restraint is essential to preserve the legitimacy of the judiciary within institutional dialogue. Moving on to the floodgate argument. The floodgate argument refers to judicial policy concerns that lowering procedural threshold too much will overwhelm the courts with frivolous lawsuits. To address this concern, the mechanism of standing is applied. Section 31, subsection 3 of the Senior Courts Act 1981 dictates that a claimant must demonstrate a sufficient interest in the matter. Although the courts have moved towards a more liberal approach for public interest groups, as seen in World Development Movement case, the fear of opening the floodgates keep judge cautious.
Miss Sharon, you know the saying, money makes the world go round. What are your thoughts on concerns over the cost and access to justice?
I firmly believe that the concerns are valid. Judicial review takes place in the High Court, making it an expensive process. In the United Kingdom, the general rule is that cost follows the event, meaning the losing party pays the winning party legal fees. In addition, severe cuts to civil legal aid mean a very few individuals qualify for state-funded legal representation. Other limitations include time restraint and procedural restrictions. In Civil Procedure Rule 54.5 states that an application for judicial review must be filed promptly and in any event not later than 3 months after the grounds to make the claim first arose. Another procedural restriction is the permission stage. A claimant cannot proceed to a full trial without first obtaining permissions from a judge. Finally, the exhaustion of alternative remedies. Judicial review is regarded as a remedy of last resort. This principle was emphasized in Cowell and Plymouth City Council. The Court of Appeal reminded litigants that internal complaints procedures, local ombudsman, or ADR must be exhausted first.
Now that we covered the mechanism behind judicial review, it all boils down to one simple question. Is it really effective? Miss Ivanka, give us your take.
To answer that question, I will be examining the role of judicial review in promoting constitutional principles, focusing on equality before the law, human rights, separation of powers, and public accountability.
First things first, let's analyze equality before the law.
Parliamentary sovereignty ensures that laws are made by democratically elected representatives. The rule of law ensures that these democratically crafted laws are applied fairly, predictably, and consistently across society. A fundamental aspect of equality before the law is that even the highest authorities in government may be subjected to judicial review, as seen in Miller II. The Supreme Court's decision over the prorogation of Parliament led to criticisms that the judges had ruled on a political matter rather than an issue within the judicial arena. It must be noted that there are criticisms regarding the effectiveness of judicial review in ensuring equality before the law. One criticism concerns the privatization of public bodies. Judicial review is only applicable to test the lawfulness of decisions made by public bodies. Another criticism involves ouster clauses. A plain and direct reading of an ouster clause often leads to a presumption that a public body's decision cannot be challenged. On the contrary, scholars argue that they prefer the anisminic approach. As stated by T.R.S. Allen, a presumption in favor of non-justiciability based on the words of the ouster clause alone is wholly misguided, stripping the words from the wider context in which they obtain their proper meaning. The anisminic approach presumes that Parliament does not intend to shield decisions from judicial review if the decision maker has committed an error of law or acted outside their jurisdiction. This approach was reinforced in the Privacy International case. Additionally, the development of judicial review protects convention rights. A great example is the Nasuri case. When convention rights are concerned, the focus shifts from the legality of the decision-making process to whether the applicant's convention rights have been violated. The Human Rights Act 1998 in particular created a major impact on judicial review. It extends the scope of judicial review in that any failure on the part of a public body to respect human rights will be subject to review by the courts. In addition, the developing ground of proportionality strives for a balance between safeguards of individual rights and the prevention of judicial activism. Furthermore, the doctrine of natural justice includes the right to a fair hearing and the rule against bias. However, if we look closely at Section 84 of the Criminal Justice and Torts Act 2015, it provides that when an applicant cannot establish that the outcome would have been substantially different, leave to judicial review must not be granted unless exceptional public interest can be proven. This has been criticized as breaching the doctrine of natural justice because it no longer fully supports the right to a fair hearing. On the other hand, the existence of alternative remedies acts as an important safeguard of natural justice. In the present case, the court recognized the importance of alternative remedies. A further concern is the general understanding that if the body was acting intra vires with respect to natural justice, the courts would not interfere with the decision, even if the decision is wrong. The next important matter we have to consider is separation of powers. Separation of powers is a constitutional mechanism that provides checks and balances, keeping decision-making bodies within the bounds of their powers, and provides remedies where power is abused. Judicial review has a supervisory jurisdiction. Its core function is to examine the legality of a public body's decision. The most crucial distinction lies in the outcome. A successful judicial review results in a quashing order or a declaration that the decision is unlawful. There will be no substitution of decision by the courts. This principle was highlighted in Mihalak and General Medical Council. Albeit this, there is no guarantee that the new decision following a lawful procedure will be more favorable to the individual than the original decision. Judicial review also provides protection against abuse of power. It acts as a system of checks and balances against executive decisions. At the same time, courts have made it clear that they will only intervene when the subject matter is justiciable. This can be seen in Nottinghamshire County Council and Secretary of State for the Environment. In the words of Lord Scarman, unless and until a statute provides otherwise, or it is established that the Secretary of State has abused his powers, these matters of political judgment for him and for the House of Commons. They are not for the judges or your lordship's house in its judicial capacity. The grounds of judicial review includes illegality and irrationality. The concept of deference is also important. As David Diesenhaus explains, Deference as respect requires not submission, but a respectful attention to the reasons offered or which could be offered in support of a decision. Finally, public accountability. One important mechanism is the doctrine of legitimate expectation. Under this doctrine, the government should not arbitrarily break any clear promise made to its citizens without a compelling public interest. Critics have expressed skepticism regarding the effectiveness of parliamentary scrutiny over delegated legislations because the parliamentary time devoted to delegated legislation is limited. J.D. Hayhurst and Peter Wallington pointed out that many issues concerning the legality of delegated legislation faced through litigation were not identified through parliamentary processes. Therefore, judicial review acts as a control mechanism that promotes public accountability of delegated legislation. In addition, judicial review involving high-profile issues often receives extensive media coverage. When courts test the legality of government decisions, there are numerous media reports discussing the legal arguments, government justifications, and the final judgments. In this way, judicial review promotes public accountability and assists public education on important constitutional issues.
That judicial review is one of the most socially important and legally fertile areas of the law due to its ability to combat abusive use of executive power. Clearly, it would be inadequate to conclude judicial review as a mere necessary tool. It is, in fact, a vital mechanism to uphold the very rule of law. In Malaysia, the court's reluctance to review the government's action, specifically regarding the matters of civil liberties, was criticized as diminishing the effectiveness of constitutional rights protections. The case of Lee Gilam versus Timbalan Menteri Hal Ehwal Dalam Negeri demonstrates the court's deference when it comes to examining the merits of the detention order given out by the ministry. However, not all hope is lost. In the 2019 case of the R versus the Prime Minister, the English Supreme Court unanimously ruled that the then Prime Minister Boris Johnson's advice to the Queen to prorogue Parliament for 5 weeks was unlawful. The court held that the executive cannot use prerogative powers to prevent Parliament from carrying constitutional functions without reasonable justification, and this decision has helped to safeguard Parliament's sovereignty. This goes to show that even with numerous limitations, the significance of judicial review cannot be undermined. Without judicial review, the rule of law can simply be bent to the will of those in power.
Our dear audience, that is all for today's episode. Until next time, goodbye.